Possible Trump indictment puts attention on prosecutorial discretion. The Manhattan District Attorney's looming decision about whether to seek an indictment of former President Donald J. Trump for a hush money payment to a porn actress has ignited debate over the strength of the case and how prosecutors should decide when it is appropriate to pursue charges and when not to do so. At the heart of the issue is the concept of prosecutorial discretion, or the leeway that prosecutors have to use their judgment in seeking to dispense justice. In this case, the public understanding of the theory of the case being assembled by the district attorney, Alvin L. Bragg, and in particular what underlying crime he may point to in order to transform a New York law against bookkeeping fraud into a felony, remains imprecise. But some of the possibilities under discussion by outside legal specialists, including campaign finance crimes, would raise novel issues. Against that backdrop, Mr. Trump and his allies have accused Mr. Bragg, a Democrat, of being driven by political motivations and applying the law unfairly, in what lawyers would call a selective prosecution. Even some legal specialists who have been critical of Mr. Trump have expressed uneasiness, while cautioning that much remains unknown about the facts of the case and any charges that Mr. Bragg might pursue. It is a power by prosecutors in the American justice system, at both the state and federal level, to decide not to bring a case, even if the law and the facts would support a conviction. In the United States, prosecutors have broad latitude to choose among a range of options in handling a criminal case, from selecting more or less harsh charges as part of an indictment, to striking a plea bargain, to bringing no charges at all. In our system, so long as the prosecutor has probable cause to believe that the accused committed an offense defined by statute, the decision whether or not to prosecute, and what charge to file or bring before a grand jury, generally rests entirely in his discretion, Justice Potter Stewart wrote in a 1978 Supreme Court opinion. By contrast, in some other countries, prosecutors are supposed to bring charges whenever the evidence would support a conviction, and decisions not to prosecute can be challenged before a judge, said David Alan Sklonsky, a Stanford University criminal law professor and a former federal prosecutor.